Hi, and welcome everyone to this month's installment of Stanford AIMI Center's Happy Hour. I am very excited to be here and joined by 7 other incredible panelists as we're going to talk about one of the issues that I've been looking forward to the most for this Happy Hour series, which revolves around legal considerations in healthcare AI. I know very little about this, so I'm excited to build upon a panel of experts that we've built here. And maybe as a first order of business, we can go around and start with some introductions. And maybe I'll just pick on people as they're arranged in my Zoom screen. So why don't we start with Chrissy?
Hi, everyone. I'm Chrissy Watson. Currently, I'm an industrial contracts officer in Stanford University's Industrial Contracts Office, which sits in the Office of Technology Licensing. And we facilitate research with companies or industry partners.
Thanks. Amy?
Hi, everyone. I'm Amy Pitelka. I'm an attorney, and I'm currently working with the Chicago Booth Center for Applied AI on a couple of different related projects.
Maybe Zach?
Hi, I'm Zach Harned. I'm an attorney at Fenwick West in their IP and technology transactions department. I focus on digital health and AI.
Jefferson?
Hey everyone, I'm Jefferson, also at Fenwick West. Work closely with Zach in the technology transactions practice group and work with a number of digital health startups as well as digital health more established companies as well, and deal with a lot of interesting data privacy, security, data strategy issues. So looking forward to this conversation.
Awesome. Hugh?
Hello everyone, I'm Hugh Harvey, radiologist, and I run a consultancy here in the UK, working with lots of startups in this space. I'm not a lawyer, so nothing I say tonight should be counted as legal advice.
And I would like to add that Hugh is our fearless creative leader and who's very nicely come up with the theme music for our AIMI Happy Hour series. So thank you, Hugh. And you could probably see his musical talents behind him with his piano. Judy, how about you next?
My name is Judy. I'm an interventional radiologist. I am not a lawyer, and I'm pretty much here to cause some trouble and oppose some things, but looking forward to learn with everyone else.
Wonderful. Trouble's good. And how about Elizabeth?
Hi, I'm Elizabeth, Senior Privacy Officer at Stanford University, and I support the university on all privacy type of questions, initiatives that researchers have, such as AI. And I also too like to cause trouble, but good trouble.
Wonderful. And my name is Akshay. I'm a faculty at Stanford University working with the AIMI Center, and I do research in medical AI. So this is very useful for me to know about what are some things I should be considering outside of just my day-to-day research. And one announcement that I wanted to make is regarding the Stanford AIMI Center, and we're very excited to have Fenwick West on board as our newest industrial collaborators. And we'll be organizing a wonderful AI legal AI office hour series, and there's more information to come about that. But just wanted to put that out there that we're very excited for this new collaboration. But maybe to get started with, how about there's a question that we get quite often when it comes to AI in radiology, especially when it comes to algorithms that can come up with automated diagnostics. Who's liable if these algorithms make mistakes, especially in the context of a lot of these algorithms being run with a human in the loop manner? How do we go about trying to determine liability issues at that point? And maybe to get started, I'll pick on our friends at Fenwick in case they've thought about this in the past.
So I'll jump in on this one in part because it's a great opportunity to plug an amazing researcher at AIMI who I had the privilege of working with, Matt Lundgren, as well as a recent Stanford PhD alum from the machine learning group, Pranav Rajprakash, where we sort of wrote a paper trying to tackle this sort of issue, specifically scoped in on radiology, and found it was quite thorny. There's definitely no general consensus yet on these things. Our initial take was, mainly digging in on physicians and seeing what their sort of liability exposure could be like, considering tort liability, so typical sort of med mal kind of stuff, where in general you're protected by comporting with custom, or going along with the standard of care. Similarly, there's a JAMA viewpoint on this that came out after our paper by Price and Cohen and Gurka that's really good and lays out these same sort of issues. So what we thought was interesting was trying to note, what would count as custom for a machine, and we sort of focused on 4 specific aspects. So in your human counterpart, normally, that person needs to have received proper medical training. They need to be able to describe, sort of how they took those findings in history to reach a diagnosis, maybe be able to identify similar cases. In the case of radiology, ostension, being able to point to, sort of something on a heat map, on the scan. And then we tried to come up with what the analogies could be for an AI system. Obviously the training is very different than medical training, but still AIs go through that stage. They can offer counterfactual explanation in some cases, case-based learning sort of explanations, kind of like the work that Rich Caruana has done out of Microsoft. And then similarly, you can use heat maps to sort of overlay. That's, a kind of pointing that the machine can do. So I don't know if I'd want to be the lawyer making this case in front of the judge necessarily, but I think I'd feel a lot better trying to make that argument if I were working with a model that had these levels of transparency sort of, built into it. The only maybe other point I'll sort of quickly make was, looking at who else could be liable. In addition to the doctor, obviously people consider the manufacturer. Normally this is something that's covered under products liability, but software has typically been excluded as a product. So it makes things a little bit tricky there. That appears to be weakening, although it hasn't been aggressively litigated yet. Maybe the one interesting thing that we noted was there's usually this learned intermediary doctrine. So if you're the doctor, we are in a product's land, like if you have a drug, normally the manufacturer is off the hook because the doctor is the middleman. He's this learned intermediary who's sort of taking that responsibility. In the AI case, there's maybe some reason to think, well, back to sort of the pill-based case, essentially, if the doctor is playing too passive a role, so if it's for something where he's not really acting learned, so for instance, like birth control, the doctor doesn't get the liability. It goes back to the manufacturer. So what we proposed is this might create an interesting synergy between the physician and the manufacturer, where they actually want the doctor to be more involved. Because if they have the doctor just playing a sort of passive, patsy in this process, then the liability could end up falling all back to them. So this might be a way that, sort of doctors and manufacturers hopefully will want to be sort of working together and coming to good solutions there. But still, it's mostly question marks. So I'll see if any of my other colleagues have interesting things to weigh in on this too.
Yeah, I'd be curious if Amy or Jefferson had any comments here, or if not, I would love to get the perspective of our MDs here about, at the end of the day, they're signing off on these reports. So what are their thoughts on this framework?
I was just going to say, I think Zach definitely is closer to some of the research and I think theory around this. I think from a sort of practical perspective, when we're representing like a digital health startup that is using AI, I think a lot of this area is so new that it's not really directly addressed, but it's usually sort of in the contracts, whether it's terms of service or some, if it's a SaaS type platform, a SaaS services agreement between the technology vendor and like, say a clinician or hospital, right, customer. Some of this sort of liability is, I guess, negotiated, whether it's through different warranty disclaimers or, there's sort of risk allocation provisions around indemnity and stuff like that. So just from again, practical sort of legal perspective, on a day-to-day when we're, again, representing, from our perspective, mostly, the vendors, digital health vendors using AI, usually it's try to take the approach that, hey, we're offering this, technology platform, and we're not the doctor, we're not, practicing medicine here, and it's a tool, right, to aid and assist and sort of shifting that risk and onus on the physician that they're still in charge of, making sort of treatment decisions, stuff like that. So
would be great to get the take from our clinical colleagues here. Is that a view that's shared clinically, or is there a different camp that the clinical folks are coming from?
Yeah, I was going to respond kind of with a question, but to your point is, I understand that what you're saying, if the doctor or clinician is still in the loop and making the final ultimate decision, then they have to accept some of the liability, and I understand that. But some of the vendors out there are making products that they claim could triage out certain studies to never have to be looked at by a clinician. And surely the liability in that case would therefore fully be on the manufacturer. And I don't know if you've got any sort of experience working in that or any advice on that.
I
Maybe
can
Zach.
jump in on this again, although I don't want to monopolize. I mean, the quick answer is unclear at this point. There haven't been any cases, where this has come up. It hasn't sort of been litigated or sort of teased out. I think, as you noted, you could make a stronger case, right? If the physician is really completely out of the loop, then maybe liability should fall less there. The question is still going to be whether the physician should be fully out of the loop. So is the technology truly good enough that the physician is justified in doing so? You can imagine the other side, right? The lawyer might say, hey, look, this technology, well, it hadn't been proven. It didn't generalize well across these other things. So for the physician, he was, negligent in just trusting the machine in this particular regard, even if the manufacturer said it was great. So there's going to be those arguments, sort of flying on both sides, and it's unclear who will prevail yet. But hopefully the judges will come to a sensible conclusion.
Yeah, the other thing to quickly add, I think there is a lot of sort of gray area here still. Again, it's all very new, and it's going to depend, as a lawyerly response. It depends, and I think it's going to depend on sort of the application, what the claims are, right, by the vendor, and I'm not an FDA expert by any means, but again, I know the FDA has this on their radar. They've come out with, various guidance documents, trying to have, some sort of risk-based framework for trying to regulate AI, right? And so the more it sort of goes towards, hey, we're making clinical decisions, right? And the more you have claims telling doctors, hey, you could rely on this, then I think there's going to be a higher standard, right? So that's just another thing to sort of keep in mind.
Actually, my comment towards this is that if we also are still exploring what it means to have the radiologist or the physician in the loop, right? Because remember, if you're there's also nested care, and then how do you capture, the current systems today do not capture the decision making of the physician. Most of the clinical notes are written for billing, right? So people will, target them towards billing. So how do you capture what was the decision making? Now, if you miss a cancer, that's pretty obvious. But how do you also, because in this system where the blame and the liability falls on the physician, then you're also missing the cases where they have to, where they disagree with the AI. How do you resolve those disagreements? And then if you look at what people are most likely, we've run some of these experiments, what people are most likely they don't care much for is that, okay, so what if you missed, you said this is a small pneumothorax, something that was going to to cut anyway. So for example, rib fractures, even if you miss them, and I think we miss them a lot, is not something that you really, because if you really think about it, there's minimal harm that comes to the patient because you missed one rib fracture. They're in pain, they'll get pain medication. You're not really changing much of their outcome then. But when it comes to missing big things like a pulmonary embolus, then those ones have big consequences. And so if you sort of look at the magnitude of what we've seen the AI systems do, they catch big intracranial hemorrhages. Everyone in the room knows that that's an intracranial hemorrhage. So, the technology has to improve, and then we have to capture, find better ways of documenting and providing incentives to be able to capture what's going on with the patient. And then the last thing is that we also have to remember the context of how care is provided. Every day, there are many, many peer review meetings that occur in the hospitals where people review each other's cases so that you see whether Judy makes the most mistakes or not. And that's supposed to be, judgment free. Actually, you cannot be sued because someone found a mistake on a case that you did in this process of sort of discovery. And so how does AI fit into this? So I think it's a big challenge, but obviously there are more interesting, sort of more immediate legal questions that have to be answered, but that's the bigger factor. I still think that we still are trying to figure out what human in the loop means for medical AI.
And then maybe even taking a step back, this was a question posted in the chat by Nish Kanwala, who says that in the past, many lab tests and PAP tests have been automated for a while, but we don't necessarily talk about those with the same framework as we talk about AI-based models. Why should we have a distinction? And if there is a need for a distinction, how do we actually make that? I'll take any volunteers.
I guess I will just offer, and I would be really curious to hear the MDs weigh in on this one, but it feels like, and Elias also in the chat sort of talked a little bit about the potential for a new field where it's a medical AI developer. It feels like there's a larger disconnect between the training that physicians are receiving and what's happening in the development of these AI models. And so not fully understanding what's happening in the model generation and what the computer is doing, I think causes a lot of problems and ripple effects across the field. My colleagues at Fenwick mentioned several times that this is just unsettled law. There's a lot of gray area. And frankly, this is all quite ripe for regulation, but we have the same issue where the regulators really don't fully understand what's happening, and the technology is developing so quickly that once kind of folks who are outside and peripheral to the field do get caught up, it's already moved on. And lawyers are struggling with that kind of across the board as well. So that might be part of the real difference here.
And maybe shifting gears a little bit, just based on some of the questions that have been popping up in the YouTube chat, there are quite a few questions that relate to IP and what does it really mean to have intellectual ownership over algorithms. So maybe I'd like to pick on Chrissy and Elizabeth to just kind of talk about what that process has looked like so far, and maybe how is IP for AI different than IP for other devices, if at all?
So I can speak about my perspective on the research side. So I'm not on the clinical side, but before we get there, and I think Akshay, you and I have worked on data use agreements and maybe some sponsored research agreements as well. And that's always a big tension that we face when we're negotiating with companies and we're receiving the data. And the big, what at least our university position is that we have the algorithm, and even if we're training a model, we would still own that model that we train on the data that's incoming to the university. And I think that it's still, I don't know necessarily if this is, the legal landscape is changing in this area, but this is the position as of today, the way that we think about it as a research institution. And along with that, I know there are a lot of issues regarding data, the privacy, the governance, all of that, which also have to be run through Elizabeth's office. So I'll let her chime in on some of the issues we face there.
Yeah, so oftentimes when I'm working with Chrissy and with researchers on these type of data agreements and data deals is thinking strategically about the researcher's perspective around the information and the privacy around the information. And so oftentimes when we're collaborating with another research institution, then it's very easy, where clearly, especially if they're also a HIPAA covered entity, we can share this information, we have an agreement, we can share it in the clear. Versus let's say you were thinking about commercializing this data set, then that's where Chrissy's team or her sister team in OTL were thinking about licensing the data. And maybe a lot of the data might have some secret sauce into it. So we might want to, strategically think about making synthetic data or dummy data as a first initial pass to provide to external partners or industry collaborators first, because we don't have all the agreements yet in place for covering the privacy rights of the individuals. So that's kind of in a nutshell kind of how we work together to help the researcher protect their IP and their data, and understand how to protect the information from a patient or a individual privacy standpoint.
And I think Elizabeth makes a great point about licensing the data, because a lot of times we kind of move around that by granting a right of use. So there's a right of access to the data and a right of use for the data for specific purposes, maybe not necessarily a license unless we end up negotiating something like that. But it would never be that the ownership of the data, especially if it's the other way, we're providing data to train a company's model, we would never pass ownership over to the company. The university would retain the ownership of the patient data, making sure it's de-identified or anonymized. So that's a big, one of the big issues, I think, ethically, that we need to consider, that we're not selling the data for a commercial purpose. And commercial purpose there is another, what's a commercial purpose?
Yeah, and perhaps, at the expense of beating a dead horse, whenever we're talking about AI algorithms in clinical medicine, a question that always comes up is, what is the patient's role in the data access? Who owns the data? If I go to Stanford Hospital, does Stanford own my data? Do I own the data as a patient? How should we think about that from a legal perspective? How involved should the patient be? And how much should we communicate with the patient if we build an algorithm using their data sets?
Well, technically, if the data is anonymized, how can you then go back to the patient and say, we've used your data? Because you don't know whose data you've used. I've always not really understood how it seems like to be cognitively dissonant to say, we're going to inform patients about how we're using their data, but at the same time say, you don't worry, your data is completely anonymized, no one knows it's your data. So maybe, I don't know, has anyone had that experience?
I mean, I think the piece is like, obviously you want to make sure when you're doing a research project, initially, you usually have a consent form. And so you're requesting the consent. So, oftentimes researchers are fast forward thinking and they're like, oh, did my consent form contemplate or provide the transparency to the patient or research subject that we're going to be doing it? So that would be my first foundational piece is we've got it in the consent form. We've let them know your information may be used in a training model or data set, but we're going to make every effort, like as Hugh said, to anonymize the information. And then thinking about who is the research subject is really important. So, people who are research subjects in the UK or in Europe have different rights than research subjects in the US. And so you have to think about what legal jurisdiction are you working with? What rights do they have? And then think based off of that, what's your strategy around how to enable that data but also enabling the research, but also protecting the privacy rights of the individual. So there's some subtleties there, like in the HIPAA realm in School of Medicine on the US side, we usually subscribe to either safe harbor or we go to a biostatistician in the School of Medicine to do an expert determination to validate that, we've got a lot of quasi-identifiers in the data set, but the risk is minimal because we've jittered the data, moved the dates around, or we've synonymized things or switched out their chronic conditions with each other. So you can't really match up who was the actual individual. So there's little tips and tricks to do to so-called add noise to the data before you release it. So that way you feel more comfortable with safeguarding your patient or your research subject's information.
That's a really interesting perspective from the research and the academic side of things. It'd be great to get maybe Amy's or Hugh's or Zach's opinion if something similar exists for companies too. Do companies think about data and access to data similarly, or are there additional considerations that have to be taken into account?
Yeah, so definitely. I mean, I think as everyone's been pointing out, data is just a huge deal, in this area. In fact, often, when we're writing these agreements, we won't use the word anonymized because one of the powers of machine learning, right, is that it's made it really easy to identify people, even who, in data sets that have been allegedly anonymized. So we say de-identified. And then often you build in obligations on whoever the licensee is. You say, I give you this data, it's de-identified, and you're obligated not to try and re-identify it. So then if you could, then you have some legal remedy, breach of contract or something like that. I think, it was really important, Elizabeth, sort of pointing out, the notion of consent, and then Chrissy also, sort of pointing out, having a specific use, right? You may have access to this data, but you might not be able to use it for a specific purpose, are just hugely important. I think this was emphasized in a very recent settlement that came down from the FTC against a company called Everalbum that was doing facial recognition, sort of software, but it was, it had consent from some of its users to use this data for, just like typical provision of the service purposes, but it didn't have this additional consent to use it for, like biometric facial recognition purposes. The FTC got very mad about this, came after them, and then in a sort of shocking settlement, I mean, it was, I think it was fairly clear they'd say, hey, of course you have to delete all that data you didn't have the consent to. But FTC went the additional, sort of step and said, we also want you to delete the models that you trained that data on, which suggested that legally there might be a lot of risk for using some tainted data, even if mostly your model was trained on other ones. If you find yourself in trouble, you might be forced to delete the whole thing. There's some possibility of maybe like technologically getting around this. I think James Zhu at Stanford has actually done some cool work on trying to sort of remove data points from an already trained model. I think, it was restricted to like a k-means clustering, so there's like, it's not a big popular industrially usable, sort of technique yet, but if we get there, you might then have that kind of defense that you could deploy if you find yourself in a similar trouble with FTC, maybe even GDPR if it comes down on those kinds of things. So I think, Elizabeth and Chrissy's point of, emphasizing finding this consent, making sure you're hitting use at the sort of right level, just hard to overestimate.
At that point, does that set a precedent that the model is a derivative from the data?
So I wouldn't go so far as to say there's sort of clear precedent there. I think on the research side of things, the work on model inversion attacks and things like that have really gone the farthest to really show, seems like the data really is embedded in the model. I mean, it's really striking, right, when you see it in these facial recognition, cases where you have a biometric identifier and it can put together a pretty fuzzy picture of someone's face. It really seems like, oh, that really looks like it's existing in the model. That's all like, the lawyers are definitely not thinking about that at this point. That's a little bit too far out there, sort of like Amy noted, often it's hard to sort of keep up. So I wouldn't go so far as to say there's sort of precedent there for any of that stuff. And even FTC's determination may have not been based on that rationale. It may have just been a little bit more ham-fisted and sort of coming in and saying, hey, you did wrong, you benefited from it, and we're going to tear it back from you no matter what. But I think it's a really interesting issue to be keeping our eyes on. I don't expect to see movement on it anytime soon, but I find it very intriguing. And if you wanted to be extra protective, you might be, sort of thinking about that as an entrepreneur.
Are things different on the other side of the pond with GDPR, Hugh? Any considerations that you've come across?
So I'll caution this by saying I'm not an expert in GDPR or the American legal system. But my understanding is that the way that Europe is heading with GDPR is it's actually harder to do data sharing over here than perhaps it is stateside. That said, there are some initiatives, at least here in the UK, to open up access to some curated NHS data sets, which will of course be relevantly de-identified and only shared with legal contracts with people who pass the test to get access. I find what Zach said absolutely fascinating, that there was that settlement agreement, and then the model had to be deleted as well. And actually, that from a startup's point of view, that's got to be slightly terrifying. I think if you find that you've used tainted data, maybe that other startups have used as well, it could affect multiple players. I wanted to pose another question, if that's okay.
Please do.
We've talked about the liability on clinicians or manufacturers for what happens if the AI goes wrong. And I wanted to sort of be a little bit more controversial and say, well, what happens if the AI is proven to be better than humans and you choose not to use the AI? Is there a potential legal issue there where you have gone against something which is theoretically provably better than human performance?
I would just say it depends what the industry standard is, right? Like the way that the law knows how to move along is by looking at what every other expert in that field is doing. And so if you're the only one who says, you know, I prefer the old way, I don't really like technology, this is freaking me out, and something goes terribly wrong, then I think you could be liable if everybody else in your field is moving forward.
So there'll need to be a bar set for industry standards, is what you're saying, for that to be the case. Okay, interesting.
I think that's
Hugh,
right.
oh, sorry, go ahead.
Go ahead.
Okay, sorry. I'm such a chatterbox here. But Hugh, I love this question. I think it's super interesting. I think about this a lot. I think, chess is a really interesting analogy, right? When it sort of started out, obviously humans, were sort of dominating the computers. Then there was this interesting sort of, a golden time when the human AI synergy were sort of the masters, outperforming even the, incredible humans. And now clearly, if you have a human trying to help out a chess AI, right, it's just making it worse. Like we're very clearly at superhuman performance, alien, sort of move 37, AlphaGo kind of stuff. Are we getting there, in these medical domains? I think is a really interesting question. One of my co-authors who I pointed out before, Pranav, has a great paper, CheckSaid, that I think maybe hints at this a little bit and showing, hey, there's a really tough problem in trying to do TB, diagnosis in individuals with HIV. They showed when you pair up this great model, with the physicians, they perform better. But actually, when you cut the physician out completely, it does even better than that. Again, there's a ton, right, to be said there. This is like not definitive, all that kind of stuff, but it at least is starting to make this question of yours real. And, how do we sort of grapple with this particular issue? This, again, it gets flagged in that sort of JAMA viewpoint I had mentioned earlier, which is great. Their sort of take was, because the tort system is so conservative, we will first, sort of provide protection for physicians who have gone against the standard of care and trusting the AI before we start to penalize them for not trusting the AI. That's likely the last step to come. I think that's probably true, but it is something to sort of have, on the horizon, and especially as we, the superhuman performance in Go moved so much faster than we could have thought, right? So similarly, I think it's going to be, it's going to be a long time before that happens in radiology, but who knows? And if it moves that fast, there might be that kind of reversal. So great question. I think it's just super interesting.
I'd like to turn that question back on Hugh. So let's say if I'm a hospital, and if I have a 1.5 Tesla MR scanner and a 7 Tesla MR scanner, where we know that we probably get better images on the 7 Tesla, but I still schedule some patients on my 1.5 T, does that make the hospital liable by not giving patients the access to the best possible technology, even though you're almost sitting on it in a way?
It's a very interesting theoretical question. I think, again, I'm not a lawyer, but I would imagine that as a patient, if you can prove that you weren't given the best possible care under the reasonable expectation of receiving it, then yes, you probably would have a case. I would imagine. we are less trigger happy with lawsuits over here in the UK than I think you guys are stateside. So I've not heard of that happening, but there've definitely been lawsuits where I think particularly in sort of cancer therapy, people have sued the NHS for not receiving frontline therapies where it should have been available. So yeah, potentially could happen eventually with AI system. There may be a point in time where, let's say 50% of the country has adopted some algorithm to do something. And if you go to a hospital which doesn't have that algorithm, you may start to question, well, am I getting the best care? And I think that, like the chess analogy, there's going to come a point where it's going to be so ubiquitous and standard of care that we're going to have to rely on it. Although it will sometimes theoretically make a mistake. And then the question is, well, how, if it's superhuman, how do we spot the mistakes, even though we know it's making some sometimes? And that's an even harder question.
Yeah, I guess everything always just relies on having good metrics to evaluate performance. And in lieu of that, it's really hard to say if are the humans failing, is the AI failing, and really trying to pinpoint the causality at that point. So till we have these metrics, I guess it'll be slow progress. But going off your statement about lawsuits in general, this just had me wonder, in terms of IP, I wanted to go back to that, is what is the defensibility of a lot of these AI-based algorithms and the patents that exist over that? There's patents about fundamental mechanisms like dropout. People argue that maybe it's more of a defensive patent, but if I only build an algorithm, say for segmentation of a very specific anatomy with a very specific modality, is that patent actually protected? How far can those claims actually go? It'd be great to maybe get Chrissy's thoughts maybe to start off with about what your perspective has been on just seeing some of these new patents come up with AI-based technologies.
Yeah, I think that I probably would have to see what the folks at Fenwick have to say about that, because I know we do rely on them a lot. And our OTL works with them a lot on that. So I think I'm going to pass it on to Zach and Jefferson.
Yeah, maybe I'll pick on Jefferson because we haven't heard from Jefferson in a bit. It seems like your mic may not be working. Yeah, but you're not muted. Maybe we'll have Zach go in the meanwhile, and then come back to Jefferson.
I can start. Oh, there we go, Jefferson.
Can you guys hear me now? Yeah. I was just going to say, I mean, that's a good question. Probably a little bit out my wheelhouse, just in terms of, patents and sort of being able to patent algorithms. We have just with IP, it's such a broad field, and there are so many different specialists. And so, again, Zach, I don't know if you have any thoughts on this, but.
Yeah, so like Jefferson, neither of us are sort of patent specialists, and you go very deep down the rabbit hole. I attended a lunch just yesterday with the patent group on AI, and quickly found myself out of my depth. As sort of a high level, issue, I think what we can, tell you is often, right, there's sort of multiple stages for the patents. You file one, and then once you get one, right, that's great, but it's actually not really worth anything until it gets challenged and it stands up, right? So there have been an astronomical number of AI ML patents. Actually, the USPTO just a couple of months ago put out a paper where they developed their own AI to categorize how many AI patents they had been putting out. And then, it just shows, right, it's this, totally exponential growth over the last 5-10 years. So there's been a ton of activity. Clearly, that shows they're comfortable with patenting a lot of things that we think, falls into the AI and ML space. There have yet to be any really big fights over it, though, right? And that's when sort of the patent law, like rubber meets the road in a lot of ways. So at this point, it all seems very open. Everyone's trying to collect their portfolios in case they are really worth something. Then, you have your sort of hoard and you can use it protectively. But we're still not at the stage yet when we're going to see these big fights and see whether it gets determined you really can, restrict someone else from using something like this, or, sort of accuse them of infringement, or that actually is not going to cut it. And unfortunately, there's no way to know until it actually gets litigated. So a really interesting area, but again, the jury's still out.
Can I jump in very quick? I've got a patent lawyer on my team, and we did a project on chest X-ray AI patents, and his report basically back to me was, like Zach said, there's going to be a fight. There seems to be a lot of cross pollination of IP, and someone somewhere is going to be infringing on someone else. It's likely that all the major players probably are. So I agree with Zach. There's going to be a big patent war. Once someone's successful enough to have money to claim, I think that will happen.
Is that how most precedents are set? Maybe this is from a legal naive perspective. Do you need to really litigate first to set a precedent, or is that something that could be done prospectively? I guess broadly, legally speaking.
I would say litigation or regulation, right? So there needs to be some kind of legislative action, or we let our beautiful common law legal system do its work slowly over time.
Got it.
Or you can all come to an agreement, right? So like, I guess to Hugh's point, I mean, to the extent that you have a number of players in the same area, you can come to a sort of détente if need be.
Yeah, that's a great point, Amy. I think last week I saw the CDT, the Center for Democracy and Technology, who does a lot, sort of lobbying the space, teamed up with EHI to create their new sort of, what they think how health data should be regulated, not as a suggestion for the regulators, but as this sort of self-regulatory framework. Right, and saying, hey, look, we think it's going to take Congress way too long to do this. This is important and needs to get done. So, hey, if you guys can all just kind of agree on, these points, we feel like HIPAA's not getting it done. What about, these cases where, we have like digital phenotyping or things like that don't, sort of neatly fit into this framework, or, players who just clearly aren't covered entities or business associates. So I think that's a really interesting, position, one we could be optimistic about, and one that we see in a lot of other industries as well, where they really sort of push for self-regulation. This has happened a lot in the auto industry, so it's definitely something possible. And I don't know, I'm hopeful about it.
We can all agree and live happily ever after. But yeah, maybe one of the questions that had come up in this panel discussion through the panelists is, this one's for the MDs specifically. I mean, right now, a lot of our conversations that we've been talking about have revolved mostly from a technology company perspective. What are some of the considerations in deploying these algorithms, and what are their legal ramifications? But as MDs, what are some of the legal questions that you think about on a day-to-day basis? And maybe we can start with Judy. In your daily life, do you think about legal issues or legal challenges that you face?
No, that would be too burdensome to walk around every day thinking about getting sued or something like that. I think, really when maybe this comes up is when you have to go through risk management, for a bad outcome for a patient, and also at that point, it's more of like, what are systemic issues that can be, so there's a lot of things that happen within hospitals, even out of the courts, and, but usually I think for someone like myself, who's an interventional radiologist, where you're doing a lot of out of the things, you sometimes have to modify something as you go along, then, you just have to overall remain safe. And I think those are just the principles, but they're not, I think for most physicians, they're not centered about getting sued, but they're centered with the north of providing the best care for the patient using the skills that you have. But that being said, I think some people have talked about, the issue of annotations, right? So there are many components of the data. So there's the X-ray, but then there's the annotation. And we know that data that is not labeled are not, it means nothing. And so some people have said that those annotations are really the IP of the people who are generating those annotations. So I'm curious, I'm going to throw this question back to hear what, the lawyers think about this. Can I patent my annotations or my dictations or something like that?
So I don't know about patenting the annotations, but in terms of it being owned as part of the university's IP, and from the research university perspective, those annotations are usually are the research results. And so our position is that we do own the annotations, and that's what's really significant in the work that we are doing when we're going through the images and running it through. So those annotations are important, but in terms of having intellectual property protection, at this point, it's something that we do allow companies to use, but it's not really included in, at least in the way that I have seen it. It's something that's copyrightable, not patentable. It sort of falls into that bucket of technology that we have produced, that we own, but it hasn't really gone farther than that, so that we segment that out. But that is considered of value and what we look closely at when we're looking at ownership and use.
Yeah, maybe to sort of just add a little to that, I think it's a fascinating question. I think Chrissy is right that probably patent isn't the right, framework for thinking of it. Copyright is interesting, right? Especially depending on how much work has gone into those labels, right? If it's very boring, it might not meet, there's like this Feist sort of test where you need a spark or like a minimal degree of creativity. So if, it's taken someone, a lot of time, they've done a very sophisticated job with labeling, these kind of things, maybe it's going to be sufficient to, meet the requirements for having a copyrightable work. Even still, it doesn't necessarily mean you get protection, right? There's the fair use doctrine, which could fall under, this area. And actually, Mark Lemley and I think Brian Casey, he's a professor here at Stanford, one of the most renowned IP scholars in the world, incredibly prolific. And he's dug in and done a lot of great work on IP and machine learning. And he has a paper called Fair Learning, where he's defending this notion of saying for a lot, of these machine learning applications, the fair use defense may be applicable. So again, it's going to depend on some of the particulars, like, is it labeled or not? Was the sort of intent or purpose of that, or, is what's being extracted from the model, something that we would deem to be falling under that sort of fair use idea. But again, a sort of novel area where we haven't seen a ton of activity, but lots of brilliant people theorizing and trying to figure this out.
Maybe peeking through the chat, there's an interesting point that came up from John Jackson, who mentioned, are AI models similar to pharmaceuticals? Most people don't necessarily understand what goes into the pharmaceuticals, but then we rely on the results of trials, efficacy, and safety. And then Hugh had a resounding yes comment, but maybe Hugh, you could elaborate a little bit more on what your thoughts are there.
In essence, it's something I've been saying for a few years now. Algorithms are the new drugs. And I don't mean that in the way that you give them to patients. It's the way that we have to develop, test, validate, and then monitor them whilst we're actually using them in real care. And the pharmaceutical industry has 4 phases of clinical trials well set out, from pre-market all the way to post-market. And we're seeing that essentially being replicated by developers and manufacturers of algorithms. So getting your FDA clearance or your CE mark gets you to about stage 3 in that, but there's a whole bit of stage 4, which we're only just getting to grips with now as we start to deploy these into the real world. And it's about error monitoring, because these things will go wrong now and again. It's about auditing, it's about reporting safety, It's about reporting accuracy. It's about watching for algorithmic drift or hidden substratifications of bias. If Luke was here, that's what he'd be saying. So yeah, and I fully believe it's just like drugs. And just like drugs, the companies have to give you all the information that's required to understand the product, the instructions on how to use it, what to do if it goes wrong, who to complain to if it goes wrong. And it has to be transparent. And they can't make claims that they haven't proven in clinical studies. So there's so many parallels with the pharmaceutical markets. I'm so glad that question came up in the chat.
But maybe as a counterpoint to that, Hugh, I don't necessarily understand how pharmaceuticals work, but someone does. The chemical biologists, they know what the molecular mechanisms and how the protein folding works. We have the analytical chemists who know how they react in different environments. So there's a sequence of knowledge, and there are standard operating bounds that we know of. For example, if I have any contraindications, I'll just be excluded from taking a certain drug. Does the same apply with some of the AI models that we're building? Do we even know if a data set is out of distribution? Things of that nature. So do you think that analogy still stands?
Yes, not to take up too much of the talking time, but yeah, I think it does. But now we're veering into data science conversations rather than legal aspects. But
Yeah, so this is another topic near and dear to my heart. I was lucky enough to, while I was in law school, I got to spend a quarter at the FDA in the digital health division under Bakul Patel, who's doing, just amazing stuff, and I think really being very forward thinking and trying to figure out how to handle these. I think, Hugh brings up a great point, and, even sort of pushing back a little bit, right? There's still even some drugs where the mechanism isn't completely understood, so even things, I think of like SSRIs, like we know why they work and why they should work. We still don't know why it takes 2 weeks for them to kick in. Theoretically, you should start feeling it sort of right away. So we don't know, but we, like you said, we feel okay because we've put it through these sort of trials. So might we be more okay with not having complete interpretability for these AI models so long as they've been put through these rigorous trials? That would be a big shift. For FDA, they've got, sort of two big sides of the house, right? There's CDER and CBER doing all the drugs and biologics, and CDRH doing, all the med devices, which is software, and now the Digital Health Center, sort of newly minted Digital Health Center. They used to be a division, really focusing on this stuff, and they're, really revamping how they work through this with their digital health, innovation action plan, trying to find out how do we sort of, deal with real world performance, and monitoring, recognizing software needs to be changed all the time. There's, I think it's, they've got their work cut out for them for sure, but they're doing an impressive job trying to engage people on these issues. They just put out a new document last month on AI and machine learning and their action plan they have sort of in place for that. So I think it'll be really fun to watch and see what they do. And it's a hard problem for sure.
Yeah. And I guess as we're approaching the top of the hour, there have been a lot of unknowns and to be seens and to be decided that have come up in this conversation. So maybe as a last pass, I want to go through all the panels here and ask them, well, if you could try to come up with a fundamental answer to one of these what if questions, what is it that you would like to see resolved first? And maybe how you would see that taking place. So maybe in no random order, I'll pick on Judy because Judy is always full of opinions first. And then we'll go snake around.
Ouch.
But I say that with the most love possible.
I know. So I think that, what I'm good at is answering my own question. So I believe that, we're seeing quite some development. I think also Nicola Peppermont is doing a lot of work about how to train models. And so let's say this year I agreed to be included in the model, but 2 years later, I don't want the model to have my training data. So how do you go to and train that, right? So God forbid that happens. But I think we're seeing quite some technological improvement. I believe that I don't honestly think that the FDA will be sufficient to see this through, in my opinion, because some of the premises, for example, even monitoring outcomes or, ongoing, ongoing post-market surveillance is very difficult for them to wrap their heads around. So I think there needs to be a form of governance and a think tank probably that, sets what are the new things that have to be done, and people can have a social contract in trying to make sure that those things are met. After all, when I have been around advocacy people, they say it takes a lot of time to pass a law, in terms of having it get into statute. So trying to have some more social approaches to governance may be what moves the field further. And in that case, then we can answer what, you won't have this cookie cutter solutions. For example, let's not include race to avoid bias, because when we do that, then we know the algorithms will be biased because we don't have an opportunity to study them.
Maybe we'll go with Jefferson next. If you could resolve one burning question that you've had, what would that be?
Yeah, it's a good question. I think one thing, and I'm not sure if it was brought up earlier, but I think in healthcare, data, there's so much data, and but it's also very sort of fragmented. We talk about data silos, right, between different providers, right, the payers, researchers, and so I think one thing that I've been sort of keeping an eye on is some of the legislation around data interoperability and data sharing. So I don't know if some of you have heard like the 21st Century Cures Act, and so there's some new regulations around that that is trying to encourage sort of data interoperability and sharing. And so I guess I'm just interested in seeing how that's gonna potentially impact how AI sort of is applied to some of this data. So again, nothing resolved there, but I think something to keep an eye on as we go forward.
Yeah. How about you, Elizabeth? Any parting thoughts about what you'd like to see resolved?
Yeah, I mean, I resonated with Judy's comment. I think that having to give individuals choice in the governance process, an easy way to choose to opt into an AI future use case would be the holy grail, because all of us want to help people feel connected to their healthcare. And so that would be one. And I think the other is to the IP protection side of the house, like more for security, like how do we ensure the algorithms are protected so that we don't inadvertently reveal or allow an adversary to use our algorithms to re-identify individuals. I think those are two burning questions that I have for the future of AI.
How about you, Amy? Any thoughts?
I will sort of pile on what Jefferson was saying a little bit, but point to another actor in this whole ecosystem that we haven't really discussed today, which is the vendors. So basically the folks who build the infrastructure that's being used by the various research universities and others. And one thing that I've come across recently is the concept of the vendors actually owning the data and managing to get this into their contracts, particularly when they're dealing with some institutions that are a little bit less savvy than Stanford. And it makes me really upset. I feel like they are the last actor in this ecosystem who should be walking around feeling like they own the data, and it has really a lot of bad downstream ramifications. So I would love if we somehow could wave a wand and make that not a possibility.
Hugh, how about you next?
So my burning question is, when will the first serious medical error by an AI make it into the headlines? And I think it's going to be at some point this year.
Well, maybe we'll
and then we'll see a lot of, but then then, as the lawyers have said, we'll get a precedent and we'll figure out where the lie of the land is. When the first judge makes a decision based on some error that goes to court, that'll be very fascinating.
we can review in our 2022 happy hour series, whether that prediction comes true or not. Chrissy, how about you next?
Yeah, I think there are two things that I would love to see resolved. And I think the first, so kind of piggybacking off of what Judy and Elizabeth and Hugh touched on, is what we kind of do in the contracts is we just assume that the data is not part of the algorithm. And then Hugh mentioned the case of when, or maybe it was Zach, who'd mentioned that the model needed to be then destroyed when we found out that we were using a bad data set. So understanding or getting more clarity around the ownership and then technically what's happening, and then marrying it to legally, what are we supposed to be doing with that? Because what we've been seeing a lot is, okay, well, now we're using a federated learning system. And so sometimes the response is, okay, so we have no data issues, we have no privacy issues, we have no ownership issues because it's just passing through and nothing's being collected. But there have to be issues there that we do need to resolve. So that would be one. And then again, the second would be sort of what Judy had touched on too, is the ethics of your data being used. And when the consent is, it will be, if sometimes we have, consent that's very specific. This company will be using the data. And a lot of times we have consent that's very general. It may be used for, research purposes. So what is the definition of when the research purpose becomes a commercial purpose? Because it's not totally clear right now. A lot of times the companies get to use the data for internal research and development. Is that commercial because they're a company? So those are the two questions that I have.
Zach, how about you next?
So Jefferson stole mine and expressed it far better than I could anyway. So I figure maybe I'll use my last seconds just to say, I loved all the questions that I saw. I'm sorry we didn't get to them all, but if you guys have those questions and want to bring them to our legal office hours in the future, we'd love chatting with you guys about it. So very excited about that.
Yeah, I'll make a shameless plug for the AIMI legal office hours that are coming up, and there's probably more information coming on that soon. But I guess on that note, I just wanted to thank all our wonderful panelists. This has been a really interesting conversation there, especially from a research perspective, because these are not necessarily the questions an average researcher considers or thinks about. So it's been very eye-opening for me, and I wanted to thank all our panelists for taking the time and joining this conversation. So thank you very much for that. But well, thanks for tuning in terms of the audience, and hope to see you next month for the next happy hour. But till then, bye-bye. Thank you. Good night, good morning, good afternoon, wherever you are. Bye, everyone.